it was early. It was around 1994 or so, maybe 95. I had come in very early one morning to do some server maintenance, and I thought, we're getting maybe 100 hits a day at that point. And I thought, well, I'll take this server down at 6 a.m. and nobody's going to notice because I had maintenance I had to do. And I took the thing down, and within 20 minutes, I'd gotten a call from the Washington Bureau of the New York Times saying, when do we get the Supreme Court opinions back? I thought, well, okay, somebody's paying attention.
Today on Law Next, Tom Bruce, trailblazing director of the Legal Information Institute, who is retiring this month, 27 years, co-founding the LII with the mission of making the law more available to everyone online. This is Bob Ambrogi, and you're listening to Law Next. We'll get to today's interview in just a moment. But first, let's hear from the sponsors who generously support Law Next. And now, on to this week's interview. Tom Bruce, welcome to Law Next.
Oh, hi, Bob.
How are you?
It's a pleasure to be here.
Good. This is actually, I was going to say welcome back, except when I did a podcast with you 2 years ago, but it was a different podcast. It was my Law Technology Now podcast, and it was on the occasion of the 25th anniversary of the Legal Information Institute.
Oh, that's right. I remember it well.
It was, and I actually listened back to it over the weekend, and I thought, it was pretty good. So I'm going to suggest that you and I just kind of sit here for the next 30 minutes, and we'll play that back, and we'll be good.
It sounds perfect.
No, we'll ask you a few more questions anyway. But so that was on the occasion of the 25th anniversary, and now here we are 2 years later, and you've announced that you are retiring at the end of June. Congratulations.
Oh, thank you.
So I thought it would be great to have another conversation with you and talk a little bit more about where you've been and what your thinking is about all of that, and
sure,
the future of the LII and your own future as well. It's always hard for me to talk about the LII because I always fall into, like what I feel like is old fogey syndrome, because 27 years ago, to me, doesn't feel like all that long ago. But, I really remember the early days of the LII because I started writing about the internet not long after you guys got going. I think I started in 93. You started in 92. Is that right?
Yeah, I think that's right. Yeah.
And it's hard for people now to understand the legal information desert in which we existed at that point, and the lack of technology that we take for granted now, especially the internet and the World Wide Web. So, I wonder if you could just start by kind of painting a picture of where we were in 1992 before the Legal Information Institute came along in terms of the legal publishing world.
Well, first of all, things were very strongly oriented still toward print in a lot of ways. And in fact, had you looked at the way that West was structuring its business at that point, it was this very interesting blend of print materials and mainframe centralized online materials in which the sales commissions still strongly favored the sale of books over the sale of online information. Lexis, of course, never had a print publishing division, but more to the point, they really controlled not just access to legal information, through paywalls, but they also controlled a lot of what anybody was thinking about legal information. There was a real sense of inevitability about it. Much later, many years later, I was approached by the Open Society Institute, which was thinking of doing some funding in open access publishing for law, asked to sort of summarize the American scene in 3 pages. I could have written about 150. But out of the three that resulted, the first sentence was, the biggest problem with legal information in the United States is that nobody knows there's a problem. And that was actually true, because for the most part, people who wanted to make use of the stuff had access and didn't really understand that there was this enormous latent market out there just waiting to sort of get their hands on their stuff, on the stuff. And if you thought about if you think about it now in hindsight, it seems perfectly obvious, right? I mean, for years there had been paper materials like J.K. Lasser's Your Income Tax or all sorts of handy little legal guides, some of the stuff that Nolo Press had done, and more to the point, in every single trade paper published by every single trade association in the United States, a monthly column saying, your business and the law, focused on the people who were in that trade or that profession. So that market was always there. The legal publishers were doing very little to satisfy it, if anything. And there was the occasional odd small pocket of stuff that had been computerized in some way for distribution. There were BBSs here and there. Cleveland Freenet was making Supreme Court opinions available as early as 1989 when Project Hermes started up out of the Supreme Court. But basically there wasn't much. And not only was there not much, there were very few people outside of industry really working on it.
Right. And in 1992, the World Wide Web was not a thing yet. I mean, it had been developed by Tim Berners-Lee, I think the year before, but it wasn't something that was publicly available at that point.
No,
it wasn't until the next year that the web kind of came along.
No, that's true. I mean, the web had roots going back to as early as '89, and there were precursors to the web that took advantage of the internet. The biggest one being Gopher, which had started out as a campus-wide information system at the University of Minnesota, hence Gopher, and we made some use of that early on because we weren't really familiar with the web technologies yet. They were still very, very, very new. And we tried Gopher for a couple of things. I think we did a version of Title 17 of copyright in Gopher that was fairly notable at the time, but we didn't go that far. In fact, we didn't even start out doing internet stuff. Peter Martin was at least as interested in revolutionizing the distribution of classroom materials as anything else. And we did a lot of work initially on CD-ROM.
Right.
We published CD-ROM materials for a good few years, up until 97 or 98, I think.
Right. But one of the fascinating things about your getting started was that you had to develop a web browser that would work with Windows because there was none then, and lawyers were already using Windows at that point. The only other web browser out there, at that point, was it Netscape at that point?
No, it was, there were actually a number of predecessors.
Okay.
There were a number of predecessors. I mean, Tim Berners-Lee had written a character-based one that ran on Telnet terminals that he ran out of CERN for a while. There were some graphical browsers that had been developed by people in the high-energy physics community who wanted to be able to see pictures. But there was nothing for Windows, and nobody who was then active in browser development, as far as I could tell, had any plans to do any. And we were actually communicating with those guys. They didn't see themselves operating outside the world of Unix systems for a long time. And at the same time, I could sit down and look at that annual survey that Chicago Kent used to do of PC usage among lawyers and see, well, there are no Macs out there and there's sure no Unix boxes. So, what's going to happen here? This is silly. We need to do something about it. So we did.
So you did. Invented the cello browser.
Yep.
So in 1992, you and Peter Martin kind of teamed up to start what became the Legal Information Institute. Peter was at that point the former dean at Cornell Law School. You were working, I believe, in education technology. Is that right?
Yeah, I was running the educational technologies group here, which is basically a computer support group. Although we had done some slightly more interesting things than changing toner cartridges over the 5 years that I ran it.
Yeah. So how did the two of you come to partner and develop this program?
Well, it was funny. It was born, I think, in some ways of mutual frustration at the apparatus that each of us had available. When I had gotten to know Peter fairly well during his deanship because I was doing a bunch of audio-visual stuff that bore directly on fundraising, which always has a dean's attention. And so we'd gotten to know each other there, but I was I was frustrated by what I saw as the lack of attention to the potential of computers among educational technologies people in law schools, and there weren't that many of them at the time. I mean, it was basically us, Harvard, Chicago, Kent, a couple others. But I thought, geez, there's so much more that we could be doing. Peter had taken the year after he stepped down as dean to work on a social security law treatise to be delivered via LexisNexis, which built in a certain number of frustrations on his part about format and so forth and so on. And we were just kind of scratching our heads and thinking, well, there really ought to be a better way to do this. And the possibility of some sort of like Cali-like consortium or something of that sort, we'd kicked around a bit. And I just remember very clearly saying to him at one point, what I really want to do is pitch a tent in the parking lot and put something under it that can actually help to develop this stuff. And so because we were not particularly original, and because in academic circles, the word institute has magical powers, it allows you to be an entity without actually committing the university to anything. Because institute has magical powers, we decided we'd use that, and calling it the Legal Information Institute seemed like a fairly straightforward thing to do. And so that was what we did. And at first, I mean, it was a complete Potemkin village. There really wasn't much of anything behind it beyond whatever Peter and I felt like doing on that day of the week. A little later,
so what did you start out doing? What was the first thing you published?
We actually started out with two things. I don't actually remember at this point what order they occurred in. We did a collection that was referred to internally as the Supreme's Greatest Hits, which was basically data that we bought from another provider and reworked in folio views with a lot of enhancements that was intended to make the 600 most studied Supreme Court cases available both to law schools and actually to people who were teaching constitutional matters, Supreme Court stuff in post-secondary education. So a lot of those went to universities. And then not long after the Supreme's Greatest Hits, or maybe before it, I honestly don't remember, we started putting out statutory supplements for use in law schools. So Federal Rules of Civil Procedure, Federal Rules of Evidence, Federal Rules of Bankruptcy Procedure, again in folio views, because at the time, that was the most capable hypertext platform we could find.
But before that, had anybody published law in hypertext?
Yeah, they had. I think if I remember right, the first hypertext venture into law was actually done by Dan Dabney, who I imagine you know, when he was still working as a law librarian, and he did, I think, the New Mexico statutes was the first thing that ever appeared on a disk. And CD-ROMs were becoming increasingly popular as materials that reference librarians, put on a desk in a library somewhere where you use it as a workstation. But there was not a lot of federal law out there, certainly.
Yeah. So at that point, did you and Peter have a vision or a mission for the LII, or were you just kind of playing around and winging it?
Well, I think to a large extent we were winging it. I think we would have referred to that as being appropriately opportunistic because nobody really understood what the landscape was looking like. But in reality, we were hot rodding, and a lot of the time we were surprised by the kind of success that we had. And we were also intrigued by some of the ways, and this is kind of an important point, the history of the LII has been in many ways as much about editorial and administrative innovation as it has been about technical innovation. We were fascinated by the fact that you could build resources on top of other people's resources. So there were all these Supreme Court opinions sitting on the Cleveland Freenet, but nobody had ever organized them in any sort of sensible presentation, either by parties or by category or what have you. So we proceeded to do all of that and just hyperlink out to stuff that they already held. We were building finding aids on top of other people's stuff. We did that much later. That was our first stab at the CFR, was building actually an index and search and table of contents on top of stuff that was at the website that GPO was then running. So yeah, we were fascinated by the potential to do add-ons and all that sort of stuff. But yeah, I mean, basically we were looking around and saying, well, what can we do with this?
Right.
And Peter's particular genius, by the way, was figuring out how you could build products on that were just enough ahead of where the market was to be useful, without confusing people by actually forcing them to learn much.
Yeah.
The history of law tech innovation is somewhat littered, at least, with the corpses of those who were ahead of their time. And we were pretty successful at not doing that early on, which was actually very beneficial to us.
Yeah. So you got started. I mean, at what point did this start to? Did you feel like you had got traction going with this? That you felt like you begin to realize you'd really built something here that had life to it, that had lasting, that was gonna continue.
Well, to be honest with you, I'm not sure I'm there yet. But and I'm not sure anyone else is either. But honestly, I mean, I can name a couple of things, where I sort of patted myself on the back and said, well, yeah, we really gotten somewhere now. The first time that happened was actually it would have been around. It was early. It was around 1994 or so, maybe 95. I had come in very early one morning to do some server maintenance, and I thought, we're getting maybe 100 hits a day at that point. And I thought, well, I'll take this server down at 6 a.m. and nobody's going to notice because I had maintenance I had to do. And I took the thing down, and within 20 minutes, I'd gotten a call from the Washington Bureau of the New York Times saying, when do we get the Supreme Court opinions back? I thought, well, okay, somebody's paying attention. And from there, it built, I can point at other moments in 2000, when we were the only people who had Bush v. Gore for maybe 14 hours. We were getting hit rates on the order of 5,000 hits per minute. And I thought, wow, there's a much bigger audience out there than we thought. But in a lot of ways, Bob, we've always thought that what we were doing made sense. And so for that reason, we thought that, it would eventually win out in some way. But in some ways, the hardest problem that we have had has been institutionalization. I mean, that's true of a lot of nonprofits. But it's been particularly so for us because we're not a particularly traditional sort of law school activity. It's unusual for programs in law schools to survive their founders. And even though my background should have contributed hugely to understanding what we were doing in this way, it took me a very, very long time to figure out that my job as director for the last however many years it is, 15 almost now, sole director, has been really to create and maintain a creative space in which this work can be done, which is not the same thing as doing the work at all. So, institutionalization has always been our biggest challenge. And I think actually now we're kind of there. But I would say that that's a development of the last few years where we've had a very sympathetic dean to help us out. So,
yeah. And I should have said, you and Peter were co-directors after founding it for a number of years until Peter retired, and then you took over as sole director.
Yeah, Peter's LII retirement was actually in 2004, I think. Yeah, or thereabouts. And it's not like I don't see him. No. Well,
I saw you guys were just together a week or so ago recording.
Yeah, exactly.
Something that Ed Walters posted on Facebook. So I'm curious to see what that is, but we will see. And so who takes over now?
Who takes over now? I have two extraordinarily capable associate directors who will take over. Sarah Frug, who has been with the LII since, believe it or not, 2001, will take over the technical side of the operation. She is extraordinarily talented and is the only person who has ever actually run both the technical and editorial sides of the operation. She started out doing editorial, moved to tech. Craig Newton, who came to us first as a student as the editor-in-chief of our Supreme Court Bulletin and graduated in 2007, spent a few years as a litigator and then came back to us and is running all of the content-oriented stuff, which has come to include both external communications and fundraising stuff as well. And they're fantastic. I have really done almost nothing for the last year. I shouldn't admit that publicly, but they've been running things, and I come in and make tut-tutting noises from time to time, and they tell me that I'm old and bitter and should shut up, and I do, and then things proceed much better than they have been. No, in all seriousness, they are fantastic. I have a huge amount of confidence in each of them. And the only thing I've really said to them on the subject is that if I come back in 5 years and recognize anything that you guys are doing, I'm going to be severely disappointed. Because the LII really does need to be sort of mutable in that way.
We'll get back to my interview in just a moment. But first, let's take a break to hear from the sponsors who generously support Law Next. And now, let's continue this week's interview. So anybody who's listening to this podcast, I'm going to suggest they might want to go back and listen to that earlier interview I did with you, or even go back to your website and read some of your blog posts and whatever about the history you've written there about the history of the LII. On the 25th anniversary, you had a series of 25 for 25, I think it was called, in which a number of noted people wrote about the LII and its impact over the years and its significance. And somehow you even, for some reason, you even invited me to submit one of those, which I was happy to do and proud to have contributed to.
I looked at those again the other day for no particular reason other than that somebody had sort of quoted one of them back at me, and I didn't remember it. But there's a lot of fantastic stuff in there, not least from you. I mean, I was very happy.
I thought they were great.
That.
I actually read them over the weekend too, to tell you the truth. In the Vox Populi is the name of the blog, I think, at the LII, and they're all there. And there's some good reading, including from Peter Martin and you and Ed Walters and any number of other people there. But I kind of, instead of kind of going back over all that history, I was a little more. I thought it would be useful to maybe talk a little bit about, as you are retiring, how you kind of size things up. I mean, one of the things you do talk about, you did talk about in your notice to the world that you were going to be retiring, are some of the things that you're proudest of over those 25 years, and talk about those a little bit. I mean, certainly you mentioned that one of them is simply having made legal information available to the public over the years.
I mean, that's the thing that everyone knows us for. And as you noted in your announcement of my announcement, there's also the aspect of it in which we really did change the conversation around legal publishing, or I should say started a conversation around legal publishing that was taking place somewhere other than in Eagan, Minnesota or Dayton, Ohio. And that I think is no small accomplishment, because there was an awful lot of suspicion and an awful lot of complacency, frankly, around the whole thing. As I said a minute ago, I'm not sure anyone really appreciated the extent to which the general public wants and needs this stuff. And so, we started something there. I think we made a couple of smart decisions in the early years. Had we tried, for example, to be a comprehensive resource for American law, we'd still be mired in that swamp. I always saw that as being much better as a distributed system. Others disagreed. But I still believe that people should be self-publishing, and we should be integrating the self-publication. I'm proud of that. I'm proud of certain specific work that we've done in collections. Most recently, the Code of Federal Regulations, where I think we're building some really interesting enhancements that are going to help people find things they need to find and look at things in new ways. Where my focus has been for the last 5 years, though, has really been on integration across collections, not just ours, but everybody's.
Everybody's meaning who?
Anybody who's putting stuff out there, for free. I mean, we have many ways to both search and sort of sniff out stuff across those collections now, and that I think is the next big challenge.
Yeah,
We've made stuff available without necessarily making it accessible, if that makes any sense.
Right. I want to go back though to that quote you mentioned, because one of the things you said is that what you thought was even more important than making this stuff kind of available was that you were able to break the commercial publisher's intellectual monopoly on legal information. What did you mean by that?
Well, actually, first and foremost, the biggest thing that was sort of staring us in the face, and I think it took me a couple of years to figure it out, was all of the emphasis on case law. There is a large part of the world, the non-lawyer world, that sees case law as an interpretive layer that they only encounter once they've looked at statutes and regulations. Basically, any non-lawyer who is using access to statutes or regulations as a way of assessing, for example, business risk, is going to start there, and then, and only then, and probably only with some prodding, then take a look at the case law that's interpreting the stuff. But they start in the statutes and regs. And frankly, I don't think the commercial publishers have ever been particularly terrific at that. But more to the point, nobody was really paying attention to it because case law is such a priority for lawyers.
Yeah, I mean that goes back to what you were talking about earlier in this recording today. Was that the audience proved to be that there was a huge audience out there whose need for legal information wasn't being met. That the audience wasn't just lawyers and legal professionals; it was the business people and members of the public and citizens of all sorts who were hungry for access to this stuff.
Yeah, and some even weirder situations than that. I mean, I've always found it terribly productive to think about what people do with legal information when they are not involved in a dispute, and maybe even when they're not engaged in trying to avoid one. So, for example, you have now a great many developing countries, or even a few states within the United States, that are putting their law out there primarily because they want outside investors to know that they have rules and they have the capacity to enforce them. If you look at what the Rwanda Finance Ministry does on its website, they're telling everybody what their financial regs are. And they're doing that as a way of saying, hey, the business climate is good here. There's rule of law, there's all this stuff. There's some other slightly more interesting cases, like the island of Jersey, which has a phenomenal collection of Jersey law out there, much of which advertises the fact that they function as a tax haven. So there are many, many, many reasons to put that stuff out there. But again, the biggest one is simply people who are going in there trying to assess some future plan, whether it's a business plan that they're looking at for feasibility, or whether they're simply asking, well, what's going to happen to me if I do X, Y, or Z, or where should I put that manufacturing plant? They've got all kinds of reasons to be looking at this stuff.
Yeah. So what did you learn about the audience for this information over the course of 25 years? Or what changed about your understanding of your audience over those years?
Well, I think, the first thing was that we were just blown away by how many of them there were. And it was only in time that we came to understand, all the stuff I just rattled off about what they were doing with it.
Yeah.
But the other thing, the other big discovery, I think, too, is that to a very great extent, American law is an export product, and the consumers of it abroad have very different needs and very different perceptions, all of which have been changed hugely by globalization of trade, and operate at very different scales. So, for example, Toyota actually pays 100 or so people to sit in Nagoya in Japan and translate American car regs into Japanese. They need those. And so the question we've always asked is, okay, well, given that Toyota does that, what do the guys in the Middle East who have an agricultural co-op that wants to sell some crop abroad do when they're interested in researching trade barriers or trade regulations or what they need for permits or anything like that? What do the little guys do? Now, the big guys develop their own apparatus for that, but what are the little guys doing? And these days, when my mother buys a toaster from the Netherlands, it's actually quite a major concern.
Yeah. If I can go back again to that point about the intellectual monopoly on legal information, I mean, what is your assessment today of where West and LexisNexis stand in the legal information universe ecosystem? I mean, maybe you've broken the intellectual monopoly, but do they still have the commercial monopoly effectively?
I think so, although I think they have some doubts. I mean, somebody at Thomson Reuters
Somebody's
announced
wondering, yeah.
Well, somebody at Thomson Reuters announced at a shareholders meeting, what was it, 3 years ago, that they no longer considered raw legal information to be strategic.
Right. They're a technology company. Yeah. Yeah.
Yeah. So, I mean, somebody's paying attention to that. And in some ways, I think they knew they were fighting a rearguard action on that a long time ago.
Yeah.
But I can't claim to speak for the hearts and minds of lawyers. I mean, there's tremendous affection there. And John Lederer, who was for a long time the guy who was the education director for the Wisconsin Bar Association, once said that the thing about lawyers is that they don't buy books, they buy systems of books for a good reason. And West, both in electronic form and in paper form, has always been good at systems of books, and Lexis has been nearly as good. So, they're not going to go away tomorrow. But by the same token, a librarian from an extremely large global law firm told me at one point that the only reason they were holding on to their Lexis contract was because Lexis had Collier, and the restructuring people wouldn't let them let go of it.
Yeah.
So
is the alternative other commercial services such as Fastcase, or is it open access sources of information?
Well, it kind of depends on how much money you've got to spend. Ed Walters does great work, and they've developed some really, really innovative interfaces and stuff there that I think people find very useful. And the commercial sector is always going to have that to contribute. The question is, how long is legal information going to be a cost that is borne by the client? because at that point, things are really going to change.
Yeah. Is it practical or possible ever for there to be a truly fully open access alternative to the kind of the Wexis duopoly?
Well, I guess if I was being slightly silly, I could respond to that question by, how long do you think it's going to be before every governmental body that anybody has any interest in is putting its stuff online in a way that's interoperable? Because that's really the question you're asking. And in that sense, I don't think we're ever going to get there. But the question is there going to be a critical mass of stuff so that people can sort of get by? And I think the answer is probably yes.
Yeah. Well, I'm not even sure I'm asking that question because I believe, and I think there are probably others in legal publishing who believe that part of the reason that West and Lexis maintain a big market share is, it's not for the primary legal materials, it's for the secondary legal materials, it's for the treatises and the law reviews and whatever, that sort of stuff. And so to have a kind of a fully open access alternative, we'd have to be getting those materials from different sources and in different ways.
No, I think that's right. And you sort of have to decide where you want to fight your battles and where you want to draw the line there. I mean, I certainly think that, things like the annotations to the UCC, the official notes to the UCC, or the annotations that are published with state statutes and all that. I mean, all of that stuff should be public domain because it's such a basic interpretive tool that it might as well be incorporated into the stuff itself. More advanced academic treatises or practitioners' guides and that kind of thing. Of course, there's always going to be a commercial market in those things. It's very, very hard to draw. I think the place where that's being fought in an odd way, sort of the hardest right now, is on this question of incorporation by reference in the regulations to professional standards and that kind of stuff. That's a very hard line to draw.
Right.
So it's a little
hard line to draw. Which way?
Well, either way. I mean, it's hard to say. Well, can we really expect standards bodies that make significant investments in this stuff to offer it up for free? If so, what's the business model for that?
Yeah.
And if we're not going to force them to offer all of it, well, where do we stop?
Yeah. Well, where do you fall on where that line should be drawn?
Well, at the point of economic viability for the open access providers, I mean, there has always been this question of, how do you pay for all this stuff that you're giving away? And I
Yeah,
think every LII that I know of has solved that differently.
yeah. Is that an
I mean,
issue for you? I mean, I know Carl Malamud has been fighting that battle, and
Carl's been fighting that battle. I mean, the people who have frankly been the most successful at dealing with that are the Canadians, who have managed to basically get a head tax on every lawyer in Canada. It's not all that big. It's like $30 a year, and that completely funds their operation.
yeah,
Which, given that the average annual expense for a lawyer in Canada for information services is, I think somebody once told me $5,000. It's not big at all.
yeah.
We have a very successful business partnership with Justia that pays for a lot of our stuff, and we raise money from supporters, which is how we pay for it. The Australians mostly do it through corporate contributions, and and the list goes on and on. There are places where it's basically an arm of government.
Yeah. Well, there are now LIIs all over the world, inspired by what you founded. You just mentioned Canada and Australia. In those two countries, the LIIs have some, correct me if I'm wrong, have some sort of semi-official status as publishers of primary legal materials.
Yeah, I mean they're the de facto national systems in those countries.
Yeah. Was that something you ever wanted in the United States for the LII? Was that something you ever pursued or thought about here?
Actually, no, because we wanted to remain nimble. I mean, we wanted to stay opportunistic and able to sort of change course. And if you take on a publication task of that size, you either need a huge amount of support or you have to give up innovation because there just aren't enough hours in the day. In some ways, I think that accounted for a lot of my dissatisfaction with West and Lexis in the early days when we were looking at what they were doing, because all of that stuff, as I've said before, was a mile wide and an inch deep.
Yeah.
And they couldn't really afford to deepen it. It wasn't that they didn't know. It was that there was no way you could viably do that. We wanted to see how deep we could go on particular high value collections. And I think just in terms of innovation and in terms of our well-developed tactic of leading through shame, I think that's worked fairly well for us.
Yeah. So how far do you think we've come in 25 years in terms of this mission of providing public and open access to the law?
Well, I mean, I suppose if I were thinking about that as a sort of question of taking a map of the United States even or the world and coloring it in with different colors depending on how much stuff people had done in different places, there would still be an awful lot of the world that was altogether blank, even a few states in the United States, and some parts of the world where the colors would be more pastel than deep, so to speak, because not that much had been done. But I think we do basically understand at this point how you can get law online in pretty much any jurisdiction in the United States, certainly any English-speaking jurisdiction. It's a little harder where there are language problems that software doesn't support and that kind of thing. But from the point of view of intellectual interest or innovation, we kind of know how to do that. What I don't think we know how to do very well yet is integration between all of those collections. Because let's face it, one of the things that makes the commercial giants the giants that they are is the fact that they've got everything under one roof. And there's a lot of interlinking and a lot of ability to look across collections and that kind of thing. And we have some of that. We need more.
So in an age when there's been, not an age, at a time now when there are any number of public and commercial sources of legal information, unlike when you started, when there were hardly any online anyway, that integration, that interoperability is that now the core mission of the Legal Information Institute?
Well, I think that's certainly what we're chasing technically, yeah. And it's everything from harvesting data from other kinds of sources to improve the collections that we have. I mean, I'll use the dumb example that I've used probably in conversation with you any number of times. If you go search the Code of Federal Regulations for Tylenol, you won't actually find it because it's regulated as acetaminophen. And if we integrate data that we get from a data store called Drug Bank in Berlin into our search there, we can search for Tylenol and find acetaminophen because we have other data that tells us what the components of Tylenol actually are. No one's yet able to do that for food products, unfortunately. But there's all sorts of enhancements that you can get through data integration, particularly of search, when you're really concerned with a thing in the real world that is being regulated that is enormously helpful. Same is true of statutes. It's also helpful for a lawyer who is looking at a reg involving hexane to be able to click on something and find out, what hexane is. I've always said there are two ways you can be dumb about a regulation. You can be dumb about the law that's doing the regulating, or you can be dumb about the thing being regulated. And we're really trying to pull those things into the same space.
Yep.
I don't know if that's responsive to your question, but it's the easiest example of integration I can sort of do off the top of my head.
Yeah. No, that's responsive to my question. I mean, my question really was on what, given the proliferation of legal information that's out there now compared to when you launched, how has that changed the core mission of the LII? And I think you just answered that.
Yeah, we've gone to integration. I mean, there's a lot of stuff on my list of projects I would love to have seen at least started while I was still active, and I think somebody will do them. I don't think we understand nearly enough about the behavior that lawyers, or for that matter anyone else, uses when they actually search for legal information. I think we make a lot of assumptions about that, but I don't think we really understand the psychology of it very well, and I don't think we really understand when lawyers move from actively desiring something that is not comprehensive to wanting something comprehensive. That to me seems to be a very important thing for us to understand, and I don't think we really do.
Yeah.
I mean, we know that when lawyers are forming the theory of a case, they look at leading cases and not much else. And then at some point, the critical mass alarm goes off and they start looking around for everything they can find. But we don't understand how that works very well. The psychology of it is really largely unknown, and we would be helped by understanding that a lot, I think.
Yeah. What's been the relationship over the years between the Institute and Cornell Law School?
Oh, it's been interesting. I mean, I think I said at one point, it's often been a good home for us. I mean, we do something that is really kind of unusual in law schools as they function today. First of all, if you look around, you do not see a lot of law school programs that really survive either the departure of their founders or the departure of their founders' interest in the project.
Right.
And we've been very unusual in that respect. We are not anything that anyone is going to see as a mainstream activity for a law school, which in some ways both Peter and I have always found a little odd, because there are many useful pedagogical things you can do if you have someone like us hanging around. But it's sort of been, well, we kind of don't know what those guys do. I do think that for some people, there's a little bit of discomfort in that there's a sense in which law schools are places that say, hi, we would like you to give us, hundreds of thousands of dollars so that we can carry you across this bright line that separates the territory of lawyer from the territory of non-lawyer. Whereas we're basically saying, well, that bright line between lawyer and non-lawyer gets pretty blurry when you start talking about somebody who is, for example, a regulatory compliance specialist or something of that sort. And I'm not sure everybody's comfortable with that.
Right. Your background was your background was not in law. You were you started out as a stage and production manager in theater. You had some training in theater.
I did.
How has that training, how has that background served you as director of the LII?
Well, it's really kind of funny because it took me a long time to catch on.
To catch on
to catch on to the fact that it was actually doing me some good. I mean, the fact of the matter was that for a long time I was running the place the same way that I would run any other collaborating team of experts. And I will say this about theatrical work: it's highly collaborative in ways that people in academic institutions just have no understanding of, because it's highly collaborative, and there's nothing quite like it in that way. But it took me a very long time to figure out that really, I mean, more than sitting around thinking up interesting technical projects to do, much of my work here as director was establishing a kind of creative space in which other people could do that kind of work. And interestingly enough, the requirements of maintaining a creative space like that where people can do that work are far more difficult just in institutional and bureaucratic terms than, building a website and populating it.
Yeah.
So I think I finally caught on to that about 3 or 4 years ago, that was what I was really doing, and that there were a lot of things that I understood by virtue of working in the theatrical trades that were really helpful in doing that. That's sort of the most I can say about it without getting into a bunch of specifics and dumb war stories. But believe me, it's been a help.
Yeah. You've been staging a production for the last 27 years.
I have. And one of the senses in which that's true is that we have been terribly, terribly sensitive, or we've tried to be terribly sensitive to audience, which is not necessarily the case with everybody who's publishing legal material. I mean, they make a lot of assumptions about what people know. And one of the questions I've asked very often, usually to looks that range from puzzled to sort of insulted, is, well, explain to me again how it is that a first-year law student looking at a statute is any different from a member of the general public looking at a general statute. Or explain to me again how it is that a lawyer who is highly specialized in bankruptcy practice, but suddenly for some business reason or because of, client appeal, needs to look at some area of law. I mean, how is it that they know anything about that?
Yeah.
How
do you maintain that sensitivity to your audience when your audience is anonymous readers of stuff online?
Well, honestly, it's a challenge, and we learn there are a certain number of things that we learn from analytics, and there are a certain number of things that we don't from analytics, and occasionally we just go ask people. Unfortunately, we're not usually able to ask them at a large enough scale to get anything more than a kind of blurry picture, but there are some things you can tell. We gathered a half a dozen people who were really using tax law into a room at one point and asked them a bunch of questions. I got some very useful things out of that we could apply across the board. But I think probably the most revelatory thing, this is entirely dumb, Google Analytics has a feature that lets you look at any web page on the site and see what percentage of visitors to the page are clicking on any link that is there. And one morning, I was looking at the landing page for the Federal Rules of Bankruptcy Procedure, and I saw that something like 35% of the people who were going to that page were clicking on a link that led to the Federal Rules of Bankruptcy Procedure. And I thought, why? Why are they doing that? They're looking at the page now, and It would seem from the numbers like they're clicking on it repeatedly. What do they think is going to happen? And after a few minutes, light sort of dawned, and I thought, oh, they're trying to figure out how to file for bankruptcy. And the minute we put a link there that pointed to a site that was helpful in filing for bankruptcy, everybody was clicking on that.
Oh, that's where everybody clicked, yeah.
Yeah, because they had no idea that the Federal Rules of Bankruptcy Procedure were not the rules you follow if you want to declare bankruptcy.
Right. So, rules mean one thing to one person and something else to somebody else.
It takes a little bit of insight to do that, but at the same time, it's sort of surprising to see what you can deduce from the analytics if you look at them closely enough.
Yeah. So, you and Peter have justifiably received a lot of praise over the years for everything that you've done in founding and building and running the Legal Information Institute. But something I don't think I've ever asked you, or who are some of the people that have inspired you? Who are the people that you hold in high esteem in this area?
Oh, well, I mean, there are a lot of people that we just think the world of. Tim Stanley and Ed Walters for two that you know. I mean, I've always admired Carl's
Tim
work.
being the founder of Justy, and Ed being the founder of Fast Case.
Fast.
A little
Yeah,
word for my
and
sponsor there.
yeah, exactly. I've always admired Carl Malamuth's work.
Yeah.
He's a little more ferocious than I would be. There are a bunch of academics and other people who have sort of chipped away at problems that we admire greatly. And a lot of people in the commercial sector. I'm having a hard time reciting any right now, but we always had enormous admiration for Frank Wagner, who was the longest serving reporter of decisions at the Supreme Court, mostly because of his candor.
Yeah.
He, he told us a lot about what that world needed. And like I say, I mean, there are a string of information scientists that we've sort of followed on a regular basis. We've looked very, very closely at what the Europeans have done, particularly the people at Barcelona and at the National Research Initiative that's based in Florence, the Center for Information Theory and Technique. We've looked a little bit at what the Australians have done, what the Canadians have done. We've found a lot of inspiration and motivation just from within our own ranks, so to speak.
Yeah.
And other odd places. I mean, there was a point where I was building a data model for the Library of Congress that dealt with legislative materials, and I found myself staring at this ontology that had been developed for digital music and thinking, oh, well, these guys really have a better handle on how to model events than anybody. And so we incorporated a bunch of their stuff. Yeah, it's funny. We've been magpies that way, and I think in some ways that's been a real virtue. We just grab a little stuff here and a little stuff there and see what we can do with it.
Yeah. Well, it's in the hands of Sarah and Craig now, but
Yeah.
what do you see? What would you like to see the future of the LII be?
Well, I think that I mean, I'm very fond of the idea of not trying to build comprehensive collections, but trying to go as deep as possible. I'm very excited by the work that Sarah has done with definitions in particular, as we encounter them in statutes and regulations, but also with entity linking, so that we can actually look at real world objects through the lens of the law, and you can sort of go in and I mean, I know one of the things she has in mind is being able to get a legal 360 on any object. The example she always uses is pseudephedrine, because it's regulated in so many different ways. You know, a long time ago, I had this idea that if you imagine what the average farm bill looks like when it gets moved into the U.S. code, it's just sort of all over the place, because the average farm bill, which is oriented for a particular population, has things in it about tax and land use and waterways and this and that and the other thing, environmental regs. And so I always kind of wondered, well, what do you do when somebody walks up to a collection of legal material and says, I'm a farmer, what do you got for farmers? Or I'm a dry cleaner, what do you got for dry cleaners? And these kinds of technologies might actually make it possible for us to provide a much more role-centered notion of information retrieval. And that, I think, is something that would be really, really desirable. I mean, if you think of the number of elder law clinics that have sprung up in the last 10 years because people are realizing, well, that's its own bundle of problems, however much those participate in different legal subdisciplines. I mean, that's the kind of thing we would really like to be able to do, to say, okay, well, what the law looks like from your perspective. You as a business owner, you as a dry cleaner, you as a person over 65.
What about you, Tom? What are you doing after June 30th?
I had for a long time been a trader and dealer in antique woodworking tools, of all things, and for the last 15 years or so, because the day job has been so consuming, I've been pioneering a unique business model in which I buy things but I don't sell them. So at this point, the weight of the tools in the basement is the only thing that's keeping the weight of the books upstairs from tipping the house over, and I really have to deal with that. I've also gone back to some very, very old roots and started dabbling once again in the world of electronic music. Doing a few performances here and there, and I think
I
there
checked
will
out your
be.
SoundCloud page.
Yeah, it's fairly weird stuff, as I'm sure you found, but it seems to be getting a little bit of an audience among the 20 people who actually care about that stuff. So, so that's going reasonably well. I've been fortunate in my collaborators on that stuff, so it's going okay, and it's certainly keeping me busy.
Yeah. And did you step away from the world of legal information entirely, or do you consider
Well,
continue to consult or
well, you know,
overlook people's shoulders or something? Or
I might well do some consulting. I'm under some fairly strict orders on that from multiple
yeah,
directions as to how much I'm allowed to entertain the notion. Uh, but honestly, it's going to be kind of nice to see what somebody else will do with it.
yeah,
You get to a point, and you must be familiar with this. You get to a point where you find yourself kind of running out of patience with fighting the same battles, and
yeah.
part of the reason that you're running out of patience is that you're not being sufficiently creative about how you're fighting them. And so I'm kind of interested to see, what kind of trouble these other guys are going to get themselves in.
Yeah, although I don't think you've ever stood in anybody's way. I mean, you've been a facilitator, not a director per se.
Well, I hope so. I mean, I've always thought that an awful lot of our, I mean, I've seen other programs that did not necessarily behave this way, but I think an awful lot of our strength has come from actually being a convener and saying, look, there are these interesting guys doing this thing over here and these other interesting guys doing this similar thing over there. Why don't you guys talk to each other? Or let's take a look at this problem holistically. And we certainly don't want to stand in anybody's way. We've got much bigger problems than any one of us can solve. Uh, and
That is true.
and somebody needs to do that. I did not mention at any point in this what I actually think our biggest deficiency over the years has been, and that is the failure to link procedure to black letter law. It's like we're publishing the rules for poker, but we're not telling anybody how to play.
The failure to link procedure to black letter law. What do
Yeah.
you mean by that?
Well, I mean, we're really good at publishing black letter law,
Yeah.
but anybody who tries to look at that and understand what they actually need to do or what might be asked of them, say in a probate proceeding or something of that sort, isn't going to get very far.
Well, you
Uh,
can't tell them that. That's the secret sauce that keeps lawyers in business.
well, yeah, some of it is. Although sometimes sometimes you wonder. I mean, I'm not at all against lawyers staying in business. I tell this story fairly often because it was a real eye opener for me. A good friend of mine died down in Pennsylvania some years ago, and the widow asked me to be the executor. There was no will. There was also no property. He was an artist, and they didn't really have much of anything. So I started looking at the procedure for being an out-of-state executor in Pennsylvania, and it being Pennsylvania, it was actually fairly complicated. So I called the Register of Wills in Wyoming County, who was a guy named Dennis, and told him what the situation was. And he said, well, I'm not allowed to give you legal advice. But if I were allowed to give legal advice, I would tell you not to come anywhere near me with this. Because, and he rattled off a list of reasons, which basically boiled down to the fact there was no property really to speak of, and there was no reason for them to concern themselves with it. And if I stepped forward with this, it was really just going to draw a lot of attention to something that they would much rather not deal with. And I thought, okay. And I said to him, well, Dennis, what don't you drink? Because given that you've not given me any legal advice, I would like to not send you a bottle of something. and we sort of went from there. But it was really an education for. I hope I haven't just gotten the guy in trouble. But honestly, for me, it was a real education in how this stuff actually works in action.
Yeah.
And that I think is something that we could all afford to pay a little more attention to. I mean, the pioneer and the clear leader in that was always Jake Warner at No Low Press. And I don't think we've stepped up to nearly enough of that.
Yeah. Well, any luck, Sarah and Craig will listen to this episode and take that gauntlet? And
Oh, they've heard far more than they need to from me on any of these subjects.
I don't know about that, but well, Tom, I appreciate your coming in and talking to me, and
it's fun.
Personally want to thank you for everything that you've done over the years, and not just everything you've done professionally through the LII, but you've been a friend and a supporter to me over the years as well, and I really appreciate it. And it's been good to be somebody who knew you and to become your friend over the years, and I look forward to continuing that relationship.
Well, as do I, and Bob, coming from you, that means an enormous amount, because you are the person who has had his eye the most closely on this scene for as long as I can remember. As I say, it means a lot. Thank you.
Good. Tom Bruce, thanks again for joining us. I really appreciate it. And
you're very welcome. It's my pleasure. I'll come back to haunt you again.
Yeah, we'll talk again. All right.
Okay.
All right, well, that does it for this episode. Thanks to the sponsor who keeps this show running. MyCase, with thousands of customers, is a trusted practice management solution helping lawyers across the country run organized, efficient, and successful law firms. Try MyCase free today at mycase.com. And as always, a big thanks to Ben Ambrogi for producing and editing the show. That's it for this week. This is Bob Ambrogi. See you next time.